for everyone who is interested. Thank you. Good questions, and the topic is hot, I understand, and we are turning to another part, to the second part, and I am giving floor to Igor Brazhevsky, who will speak about administrative liability issues at the time of COVID, meaning that there are certain restrictions and recommendations of the Russian state authorities implemented during the threat of COVID and the period of COVID last year, and there were probably some sanctions and liability, and what should we do with all this? Igor will explain us now. Thank you, Igor.
Yes, thank you, Alisa, for introduction. Good morning to everyone who joined our webinar, and we are now starting the topic dedicated to administrative liability issues at the time of COVID. So, of course, the situation with COVID presented a lot of difficulties in terms of introducing a number of restrictions, a number of requirements, and of course, all this leads to the fact that administrative liability issues were quite important and are still quite important. So just one second. Yes, so let's start our presentation. Basically, what I would like to say in the beginning is that in the year 2020, a lot of requirements from state authorities were introduced, and these requirements appeared in a quite a short period of time. Also, they were changing quite on a constant basis, and all this presented a lot of difficulties just to understand what is in force, what should be followed, how should be followed, and all this was quite difficult. And even though that situation with pandemic, at least what is told to public, is that situation is being improved according to statistics, and still these requirements which are presented on the slide are in force. At least there is no information that the requirements are cancelled. However, considering that situation is changing very fast, we can also expect that at some point all these requirements will be fully or partially cancelled or changed. But let's stick to the issues that are currently in force. So first of all, we should say that there is a requirement for cleaning and disinfection, and even for office premises where just employees work using a computer, this clean and disinfection also is applicable. Even if we have just 1 or 2 employees, still this should be done. And moreover, there should be a special schedule and the registration book that can confirm that everything is done properly. And in case of inspection from Rospotrebnadzor, the competent authority, their duty would be to present the confirmation of fulfillment of all these requirements. So the schedule and registration book should be presented and shown to the inspectors from the authority. The other issue is that still the so-called masks regime is in force, and for the employees it is important that the employer provides the employees with these masks, and there should be enough masks for 5 days, and at least for 5 days, and it should be changed every 3 hours. And what is also important, that in case of any inspection from the authority, the confirmation should be that all the employees are wearing these masks. And if this is not done, this will be considered as a violation, even though there are masks in the office, but still the duty is that employees should wear it. Also,
sorry, Igor, very sorry. I understand that no one can see your presentation. Could you please share your screen again? Try to make it again.
Sorry, just sure that it's shown. Okay, so just 1 second, I'm trying to solve the situation. Okay, so is it
Yes,
okay now?
great.
Yes,
Yeah,
so,
yeah, we can see it.
sorry,
Yeah,
it seemed to me that it was working, but unfortunately. Okay, so now everything is fine, I hope. Okay, so
absolutely, we can see it in full screen mode. It's
sorry
great.
for any inconvenience. So let's continue. So the third issue is the essence of so-called antiseptics in the office. Another issue is the daily measurement of temperature, and also it should be a corresponding registration book where these results of daily measurement are kept. So in case of inspection, we should show to the inspectors these registration books, and only this document may confirm that the requirements are duly fulfilled. What is next is that the company, the employees should have the thermometers for measuring the temperature. There should be also a so-called entry filter in the office, which assumes that there should be a temperature checks for the employees when they are visiting the office, when they arrive into the office, let's say. And if there are any high temperatures with the employees, such employees should not be let's say available for any employment activity, and should go home and work at home. So another issue is the social distance, which means that there should be a distance of at least 1.5 meters between the employees. So the working desks should be placed in such a way that such a distance is ensured. Moreover, there should be a specific medical tests about the COVID that every 10% of employees should pass, and this should be done every 15 days. For Moscow, there are no restrictions in terms of, let's say, no exceptions in terms of the number of employees. So it means that even if we have the company with 1-2 employees, these medical tests should be done. However, in Moscow region, for instance, we have an exception that the medical tests are only required if staff is more than 100 employees. We should say that all these so-called requirements, in fact, are at least they are passed as recommendations. So it means that, frankly speaking, this is not, let's say, obligatory rule to be followed, and it means that there should not be any liability in case of non-compliance with these recommendations. However, the court practice in this regard is quite contradictory, and there are cases when the liability for non-compliance with the recommendations was introduced, and we would like to speak about the possible liability and the solutions how to mitigate the liability and how to solve the occurred situation. So first of all, the liability for non-compliance with the recommendations can be in two different ways. One possible option is the official order or prescription that is issued by the competent authority, which means that this is just a prescription not to continue the activity with violations, with non-compliance, and which means that the situation should be just improved and should not occur in the future. Another possible way is that competent authorities may issue administrative fines, and the fines will be issued for the officials and also for legal entity. Moreover, it is also possible that the activity of legal entity can be suspended for the period up to 90 days. If in case there is a situation with administrative fine, first of all, the important issue is how to challenge it. There are basically there are two options for challenging the administrative fine. The first option is to apply to the superior authority and to use the so-called out-of-court procedure to challenge the administrative fine. Basically, this option is not always preferable because quite often superior authorities do not change the decision of the lower authority, and this option with challenging the fine is not working. So the better option would be to apply to the court and to use the option with challenging the administrative fine through the court proceeding. However, we should also note that using the out-of-court procedure, if we use the out-of-court procedure, the period of reviewing the application will be limited to 15 days. If we use the court proceeding, the period of resolving the case through the court can be up to 3 months. Important also is that the burden of proof of the occurred offense is with the state authority, which means that state authority should present the documents, the confirmations that justify the occurred offense. And so this is the obligation of the state authority. At the same time, it is important during the inspections from state authorities to check any kind of procedural violations from the state authorities, because if there are such procedural violations, it can be used further in the court, and the administrative fine can be successfully challenged, and this could be a good option. So basically, the court, while reviewing the case with administrative fine, first of all, will check whether the offense really occurred and whether there are any procedural violations from state authority. So if there are such violations, of course, the court will take it into consideration. Another important issue is sometimes low significance of the occurred offense is taken into consideration. However, we should say that this is quite tricky issue, because some of the courts may consider this important, some courts will not review it. So it's always a kind of discretion from the court. But it is useless. It is useful to still to try to use the law significance if it is applicable for the current case. We would like also to mention that in the year 2020, we faced with a lot of examples in the court practice when the administrative liability was mitigated, and the situation with COVID was also used as an argument, and the courts quite often accepted it as a ground for mitigation. And in court cases, quite often the administrative fine was abolished, and just an official warning letter was issued. So also the administrative fines quite often were decreased. And as an argument, current economic situation in Russia, that of course was affected by the COVID quite significantly, was used as an argument and was considered by the courts. Also, quite often another arguments were used. For instance, it was the argument that administrative fine is too severe and disproportionate. Another argument was that administrative issuing of administrative fine may lead to full stop of commercial activity. And the idea of administrative liability is just the prevention of the violation and not to stop of commercial activity. So these arguments were also used, and the courts took into consideration these aspects. However, we should say that based on the court practice of the year 2020, we may say that just argument of COVID is of course not enough. And the other argument that should be taken into consideration is that there should be no infliction of harm to people or state security, and there should be also no risk of such harm. And of course, depending on the type of the occurred offense, situation may differ, and there could be infliction of harm or to people or state security. And in this case, the argument with COVID probably will not be a solution. We also should consider that the character of violation and its consequences, as well as financial situation of the company, are also taken into consideration. And in the current practice, the situation with COVID is quite often considered in favor of the penalties decrease. The possibilities to decrease administrative fine are the following. First of all, quite often in our legislation, in the Code on Administrative Offenses, we see that for quite insignificant offenses, we have quite severe administrative fines. For instance, if we are speaking about reporting to the Migration Authority concerning payment of salary for the highly qualified specialists, we have a quite severe administrative fine. And even if there is a delay in this reporting, or if we are using the form of notification that is not enforced, we can receive a penalty of almost 1 million rubles, which is of course quite a disproportionate amount, I should say. And even if administrative fine is legitimate and proportionate, it may be also deemed as considerable. And these arguments can be used in the court proceedings, and the courts may take it into considerations. Also, we should say that administrative fine could be decreased quite significantly and even below the statutory limit. And what is considered is that limitations due to COVID can substantially interfere the economic activity, which means that there should be some kind of connection between the situation with COVID, between the introduced requirements and limitations and its influence on the economic activity of the company. So all these arguments and evidences should be presented, and in this case, the court probably, and there are confirmations in the court practice, will take into consideration. However, we should say that the financial situation of the company itself is mostly deemed as an optional circumstance that itself cannot help to decrease the fine, which means that just referring to the bad financial situation is not enough to receive a mitigation of administrative liability. And we should say that there should be other exceptional circumstances that are connected with the character and the effects of the offense. Moreover, there should not be any so-called aggravating circumstances. For instance, there shouldn't be any previous commitment of the same offense. Ideally, there should be some mitigating circumstances. And if let's say the offense is insignificant, this also should be used as an argument. Moreover, we would like to say that the difficult financial situation has to be confirmed by evidence. And as an evidence, we may use accounting reports, bank statements, and other documentation. So it's not enough just to say that we have a difficult situation, but rather we should confirm it by the respective documentation. However, we would like to say that in the year 2020, there were some cases when in case with COVID, the confirmation of the financial situation was not so strictly required. However, just to avoid any kind of difficulties, any kind of problems, it is advisable to present all the documentation and to justify the bad financial situation. So it's just an advice to be on the safe side if we are trying to challenge the administrative fine. As mentioned, not only there should be not only reference to the current difficult financial situation, but there should be also the argument that we may present to the court, saying that payment of administrative fine may lead to further aggravation of financial situation, because if the fine is paid, the company will not be able to fulfill the contractual obligations, will not be able to pay salary, and all this, of course, can present a lot of difficulties. So sometimes the courts consider this as an important argument, because the idea of the administrative fine is not to stop the economic activity of the company, but rather to just not to lead to the fact that the same offenses will be committed in the future. So this argument about the financial situation and further aggravation of situation due to payment of fine should be also taken into account, should be used, and most probably the courts will take it into consideration. So basically, I've tried to cover the main issues connected to the current situation with the main requirements that should be followed, and just we discussed the situation, how to challenge the administrative fines, what kind of tools we may use, and possible arguments we can use for the court proceedings. So I'm ready to answer any questions.
Thank you, Igor. Again, while maybe our audience is thinking and writing their questions in chart, I will ask you a question. As far as I understand, the situation when there is some liability for non-compliance with certain restrictions or recommendations, whether it will be a warning letter or a fine or any sanction, it's fully at the discretion of the authority, of the state authority who is making it. So there is no rule that first time is always should be a warning letter, but it should be grounded on character of offense by the state authority and decided at place. Is it right?
Yes, this is right, because according to the law, either an official warning letter or administrative fine may be used. And from practice, we can say that in some cases, the authorities use just a warning letter. Sometimes they issue an administrative fine. So always unpredictable, we could say, and depend on the probably on the employees of the competent authorities, how they estimate the occurred offense and what arguments they are taking into consideration. But of course, I think that if the fine is issued, we should use all the possible options to try to mitigate the liability, or even to cancel it. And there are enough examples in the court practice that confirm that it is possible, and the courts can accept this as important issues. Of course, we cannot be 100% sure that the courts will take it into consideration, but at least we may try, and we should try.
And I think that these court proceedings may affect the way the state authorities assess and how they treat these actually offenses, the characters, and maybe there will be less fines and more warning letters, at least for the first cases. I see no questions on these presentations from our audience. It means that it was all clear and very full, informative. Thank you, Igor. And to finalize it all, it's the third webinar, as Amanda told in the beginning, and it's the final for this topic of new legislation in Russia at the time of COVID-19, because it's New Year starting now, more to come, we hope, not connected already with the pandemic, but we hope to continue providing you with this way of interaction and updates of the legislation and working in Russia, and we'll be happy to see you all again. Later on, we will probably announce new webinars for all of you. Thank you.